Well, several of the pitfalls that you need to be extremely aware of, especially in HR or as an executive or management. One is invasion of privacy. If you're monitoring what employees are doing during the day, at what point do you invade their own personal privacy? Most of you are probably thinking if they're at work, there is no personal privacy. You'd be wrong, especially according to a lot of very, very recent case law. Also, as we talked about, you need to be sure that you're monitoring for harassment. If you have monitored an employee and you see harassing emails back and forth between him or her and another employee, you need to take that into consideration and you need to do something about it, especially if you have policies in place which prevent harassment, which I'm sure most of you do. You need to make sure that they're enforced, especially when it comes to electronic communication, so that at a later date you don't have somebody saying, well, I didn't know you were monitoring my email. Also, you need to be aware of discrimination claims, and that is mainly for people who are saying that you are not enforcing your policies correctly, or you're only monitoring one particular employee because of his race or because you don't like her for some protected reason. You also need to be careful when you're monitoring for whistleblower and retaliation claims. There are whistleblower laws that protect employees who complain about such things as health, safety issues and violations, and securities fraud. So if you're monitoring an employee and you come across information where they are sending emails to the Health Commission about something about your workplace, or they're sending information to the EEOC about your workplace, you cannot retaliate or discriminate against them. So unless you're enforcing policies consistently for everyone, that person can claim that you're actually discriminating against them, and if they get disciplined or terminated, they can have a retaliation claim against you. You also need to make sure that when you are monitoring somebody's internet activity during work, that you're not violating the National Labor Relations Act. Lots of the unions will put these into their contracts, but the National Labor Relations Act protects employees' speech, especially if it relates to work conditions or pay. So when you have that employee who maybe is covered under a union contract and they're writing an email outside of work to a friend talking about how they can't stand their compensation and that other people are getting paid a lot more than them, you have to be careful about actually using that type of information against that employee, because you could be violating the NLRA or the union contract for that matter. Again, like we talked about, you need to be careful that you're not using the information that you find against the individual in a state where they protect non-work lawful conduct. And that does not mean that everything that you find on the social networking sites can't be used against somebody. If you see somebody who is committing crimes, that's not lawful conduct, and you can terminate somebody for that. In fact, especially in Florida, what we need to consider is that Florida is an at-will state. So generally, you can hire or fire somebody for any reason that you want or no reason at all, as long as it's not a protected reason. And that is what you're looking for in all of these contexts, especially when monitoring. You need to make sure that you're trained and that everyone knows what those protected categories are in your particular state, and that your policies are centered around making sure that you are not going to violate any of those. Again, like we discussed, protected political speech in some states, including California, and employees' First Amendment rights. That's mostly when you are involved in public employment. I'm not sure if we have anyone on the line that is involved in public employment, but if you have employees that are talking about certain political aspects or issues of the day, you need to make sure that you're not invading their First Amendment right to that speech. Invasion of privacy is one of the biggest litigated areas right now. The Electronic Communications Privacy Act prohibits employers from intentionally intercepting electronic communications or having unauthorized access to e-communications that are stored in e-files. Now, I know that sounds pretty complex, but basically, you're not allowed to intercept communications that people are doing on the computer except if you have consent or there's a business purpose. And if any of you have had experience with litigation before, do you know that gaining consent, especially if it's not written or proving it, is very difficult, and a business purpose can be very broad. One of the cases I put up here as an example is this Arias versus Mutual Central Alarm. Mutual Central Alarm Company had a policy and practice that they recorded all incoming and outgoing telephone communications. And that's so because they were hooked up to alarm systems at people's homes. So when people would call in for an alarm, they needed to know and be able to access that information for a certain period of time. So what happened is that the employers were intercepting the private telephone conversations at the workplace. Two of the employees who were not aware that their private telephone conversations, as well as every other conversation in the company, were being intercepted, filed a lawsuit alleging violation of federal wiretapping statutes as well as invasion of privacy. Now, this particular litigation is interesting because in the course of what actually happened was in the course of a dispute between Arias, the plaintiff, and Mutual Central Alarm following her resignation, the human resource manager, Rubin, began to suspect that another employee who was also involved in divorce proceedings with the human resources manager's granddaughter, but was having an affair with the plaintiff, was a faithless employee. It was during that time that the employee and the plaintiff allegedly first became aware that the employer had been continually recording their telephone conversations, and that included all employees, not just these two. And of course, Albero was the other employee who was having the affair and was actually terminated. The problem was, what the court discussed in this particular case is whether Mutual Central Alarm had a legitimate business reason which supported the continual recording of all incoming and outgoing telephone calls at their place of business. One of the things the court actually discussed was at what point in time did the business purpose end and the human resource manager was actually having some personal stake in the conversation. If the employer had a policy of recording every conversation, which this company did, that's fine. But then the question became, you can intercept all of those and record them, but when can you actually listen to them? When is the content protected? And the court goes on a long ways about just knowing that there are communications back and forth as opposed to actually reading the content of those conversations makes a big difference. In this particular case, the court struggled with the fact that once the human resource manager found out that there was an affair going on, he should have stopped listening to the content of the information. In this particular case, the court did find that there was a legitimate business reason supporting the continual recording of the outgoing telephone calls, including the employees. Now, one of the things that was also discussed is whether the employees had a reasonable expectation of privacy in those private phone calls that were made on employer systems. One of the things the court dwelled on was the fact that the employer did not obtain consent and advise their employees that their private phone conversations would be intercepted, or, for that matter, could be intercepted. The key in most of these cases is reasonable expectation of privacy. If the court finds that an employee has some kind of reasonable expectation of privacy in any form or content, and we're going to talk about that briefly, then they may have a suit against you. The problem with that is that you're thinking as an HR manager or executive, you don't have any expectation of privacy, and certainly not a reasonable one if you're using my phone, my computers, and you're at work earning my money. Well, the problem with that is the courts find differently in several cases. So one thing you need to be concerned about is making sure that your employees do not have any reasonable expectation of privacy in any manner. Now, the courts are going to prohibit you from, for instance, reading confidential private communications between the employee and their attorney, even if it is at work. But to the extent you can make human resource policies that protect you against any employee thinking that they have a reasonable expectation of privacy in any aspect, that's what we're going for here.